Next topic we're going to talk about is volunteers. And again, we set this up, originally we put it as a session for the Fair and Events Directors segment. I know I've done some training on volunteers with HR directors. I've done some volunteer training with the UCIP group, the commissioners group, over the years. But we eventually moved this into this general session because who in this room has never at least contemplated using volunteers in their department? Anybody? We use volunteers everywhere in the county, right? We could not do county government without volunteers. And the question that I have is, with the pandemic, and we all know there's a shortage of workers, right? We all have open positions that we are desperately trying to fill in our counties. And is that going to equate to also a shortage of volunteers? If people who used to take time they've been retired, semi-retired, and they're volunteering, and now they're being begged to come back to work, and we'll pay you a signing bonus, and we'll pay you better than you've ever made before, and all of these things, are we going to run into a shortage of volunteers? I'm afraid that is going to be the case. So we need to manage them better. And with COVID and now this potential second wave that we're seeing of COVID, and who knows how many waves we'll have, will there be a reluctance of volunteers who do want to volunteer to come and volunteer for us? That's another concern that I'm afraid we're going to face. At the same time, there's been an increased number of federal volunteer programs that have popped up, and a lot of those federal programs pay their volunteers. I'm not sure why they call it volunteer programs anymore, but they do compensate them for volunteering, and so now you have to compete with federal volunteer programs that are potentially providing benefits to your people that would volunteer for you. Some of those we'll talk about are great resources to let them volunteer to the feds and then have the feds provide you the volunteers. You still get the work done, but they're actually the feds volunteers. We'll talk about that later in my presentation. And of course, all of this is dependent on your location and the type of volunteer services that you want. There are some places in this state where it does not matter how bad things get. There are going to be people that are going to volunteer for that fair every single year because it's their life, right? And there are other places where volunteerism just isn't as much of a thing as it used to be. I mean, luckily in Utah, we're one of the highest rated volunteerism states in the country year after year. That's great, but once we've gotten used to that, having volunteers ready to be there for us, and now we have this potential that we might not have that so readily available. Again, we need to look at ways that we're going to utilize our volunteers best possible way. So let's talk about volunteers in Utah. So generally, volunteers in general are just that. It's people that they're happy to provide their time and service, and sometimes their personal autos and equipment and things like that to help out a cause at their own cost and at their own risk. And under the state law, there are several immunities available to people who volunteer in that way. And we'll talk about those later this morning. And again, those are all meant to protect the volunteer and to incentivize volunteerism in the state of Utah. The legislature's always been very good about that, about passing laws that protect the volunteers so that we can have more people provide volunteer services. But the problem is, and we saw several new immunities created during the legislature. Just because I tell you that there's an immunity for something does not mean that you're not going to get sued for that. It also does not mean that you're not going to spend an awful lot of time and effort in the courts defending the fact that you have an immunity. I would say that of the lawsuits that are filed against the counties that UCIP handles, probably 80% or more, we are defending the immunities. that the county's immune from this lawsuit being filed. And we spend millions of dollars every single year defending claims that we supposedly have an immunity for, but we spend a couple $100,000 every case to get the court to the point where the judge says, you're right, you have an immunity, I'm dismissing the case. So when we talk about immunities today, that does not mean you do not have any liability. It just means ultimately you're likely not going to pay any judgment, but you will keep in close contact with Corby for several months. Injured workers, volunteers would typically bring a lawsuit, the same as any third party. If they're injured volunteering for someone, if they're volunteering to a charity and they get injured, they just sue them for negligence like anybody else would. Some companies, though, to try and protect against that, purchased injury policies for their volunteers. You know, I used to be a referee, a motorcycle referee for bicycle races for the USA Cycling Association, and that's what they did. First of all, they had like a 7-page waiver. And I haven't spent enough time with the county attorneys to have been able to read that thing and really understand all the legalese that they had in there. But they did provide an injury policy that if I was injured while I was reffing, that they would pay for my injuries to a certain limit, in hopes that I would just accept that and not try and file a workers' comp claim against them as a volunteer or not try and sue them for my injuries. And so a lot of typical people who provide or utilize volunteers, that's how they deal with the situation. And almost all people who use volunteers use some form of a waiver that you're volunteering on your own, if you're injured, you know, are sued, something like that. Sorry, but you're on your own. Not our fault. But before we get to the counties, there's specific immunities for nonprofit volunteers. 78B4101 provides immunity for volunteers to nonprofit entities and the nonprofit agency. So both get immunity under the statute as long as the volunteer was acting in good faith, except to the extent the nonprofit has insurance covering the volunteer's actions. So if any of you are involved in a nonprofit, just understand when you get volunteers, first of all, you're going to end up in court, even though there's an immunity, to prove that they were acting in good faith, because that'll be the argument. The volunteer was not acting in good faith, therefore the immunity does not exist, and you're going to pay us. So you'll be in court. And to the extent that that nonprofit has insurance for their volunteers, this immunity doesn't exist. So that's a question every time that a charity uses volunteers is, are we buying insurance for the volunteers? If we do, how much are we going to buy? Good question. We're not going to tackle that one today, because we're not nonprofits. And of course, they have an exception to this immunity for volunteers, because nonprofits that if they get in a car accident, all bets are off. They don't get immunity for car accidents. Then we have government volunteer immunity. So under 63G, Title 8, there's the Immunity for Persons Performing Volunteer Services Act. And that act provides immunity for a volunteer under the general supervision of a public entity, has immunity unless the actions were grossly negligent, not made in good faith, or made maliciously. So you can see the standard's a little bit higher, right, than it was for the nonprofits, that it needs to be gross negligence, malicious intent, not made in good faith. So a little bit better situation to defend those immunities for volunteers to government. And again, there's an exception to any time that they're using an automobile. The But that's the general immunity for volunteers that we're going to use to defend your volunteers. But we will be defending them because you are required to defend them. This is the act that we're going to spend most of our time on today. Utah Code 67-20, Utah Volunteer Government Workers Act. The act defines a governmental volunteer, who that is. It identifies exceptions to who is a volunteer. It identifies purposes for which a volunteer is an employee of the public agency, and identifies benefits provided volunteers with exceptions for certain volunteers, because the legislature can never make it easy. There's always hoops. And it provides for experience credit for government volunteer services, which may be a good way to be able to recruit volunteers, as they can get workforce service, volunteer service credits that are important. So, all right. So we start out with the act. The act actually prohibits unauthorized volunteer work being done for any public agency, because the act reads, a person may not donate any service to an agency, may not provide any service to an agency unless they are approved and authorized under the requirements of the act. So somebody shows up and decides that they're going to plant some flowers out in front of the courthouse. You didn't ask them to. You don't have a volunteer program for planting flowers, but they decided that the courthouse needed to be spruced up. They show up on Saturday morning and start planting flowers in front of the courthouse. They are trespassing under the law. They cannot be doing that. They need to come to you and be authorized to be able to provide that service. If that's the argument, that they're providing an argument to or a service to the county, they're actually violating the law. Yes?
So to be clear, like the Eagle Scout project, we need to...
You should have that coordinated either with the individual scouts as volunteers or through the VSA to that they are providing those volunteers. Your agreements with the VSA. Plaintiffs who don't want the volunteer protected by the immunities and the tort caps, because again, when we talk about the act, it says that for certain purposes, they are your employee. And plaintiffs' attorneys aren't going to like that volunteer is your employee if they injured their client, because they don't want these tort caps that they can only collect a maximum of $750,000 per person that got injured, total maximum of $3 million if a ton of people got injured by your volunteer. That's the maximum that they can get, and they might get zero in 90% of the cases, right, Corby? They're going to get zero because the courts are going to throw it out based on the immunities. We just read the immunity for volunteers. So they don't want your volunteers to be considered volunteers under this act. So they're going to argue that the county was negligent in allowing the individual to perform volunteer services when they weren't actually authorized to do so. So that's why when we talk about the process to authorize volunteers, take it seriously, get them authorized, because that will be a very good argument for a plaintiff to make, is they shouldn't have even been there. They were violating the law by being there volunteering when they weren't authorized to do so. Not just that they weren't authorized, they were violating the law. So let's look at the definition of a volunteer under this act. It means any person who donates service without pay or other compensation of any kind, except expenses actually and reasonably incurred as approved by the supervising agency. It goes on to state that volunteer does not mean a person participating in human subject research. And there's a lot of kids doing that with the university right now. I don't think that any of the counties are doing human research and have subjects volunteering to you, but that is one. And then a compensatory service worker, which is important for us, and we'll get to what a compensatory service worker is, but they are not considered volunteers under the Act. compensatory service worker is a person who performs a public service with or without compensation. So it's odd that volunteer says no compensation. But compensatory service worker is not a volunteer, so they can get compensation. And they provide this service to an agency as a condition of their incarceration, a plea deal, sentence, a diversion, probation, or parole. So these are the guys in the orange jumpsuits, right? Yes?
Got a question. Are our appointed boards like planning commission, are they considered volunteers with this?
Very likely so, yes. If you appoint them onto the committee, well, now they're an appointed official. So they would follow the rules of any appointed official of the county. But if they're more voluntary than appointed by the commission to serve as a board member, then they fall under this.
So by that sense, I think we should probably have them approved, yeah, by the HR director.
Doesn't hurt.
Thank you.
Yeah. So again, if you've got work programs at the jail, things of that sort, all of those people, if at the time that they get injured or they do something to injure somebody else, they're actually providing service to you, then for sure they're covered under this act. But it also said under the general supervision of the county, in the immunity, it said if they're under the general supervision of the county. So even if that inmate is providing service to some other company in the county, they still have the immunity provided to them, but they're not an employee under this act because they're not providing the service to you at the time. Does that make sense? Again, they're not a volunteer, but they do have some benefits under this act. Now, we saw in the definition that they are not to be compensated other than actual expenses, and I get this all the time. Well, we just give them, just a little bit per run. We just provide them, a meal per diem when they're on call or when they get called. So it's not much. Well, it doesn't matter. In statute, no, none means none. No compensation. So as soon as you start doing those things and compensating them, if you want to buy them lunch, have them bring the receipt from Burger King and reimburse them their lunch. You can do that, but you cannot give them $25 per diem and say go and buy lunch. Now they're a full employee and get all benefits of being an employee because you're paying them and they're not a volunteer. What do you call somebody that's paid and not a volunteer? What is that? An employee, right? So again, my idea, and I know I've dealt with this specific one. Well, if they volunteer at the fair, we give them rodeo tickets, we give them concert tickets. Okay, well, now they're an employee if you compensated them. There's no question about that. But if they're volunteering while they're at the rodeo or at the concert, like, okay, we're going to give you this ticket to go into the rodeo because if there's an emergency during the rodeo, you're going to assist in ushering people out calmly and correctly through the exits. That is what your volunteer duty is the night of the rodeo. You're not compensating them, are you? You just need that staff inside the rodeo. I'm not trying to find loopholes for you, but okay, I'm trying to find loopholes for you. But be creative with that, but be very careful that you're not compensating, that there's a true purpose for the things that you are giving them. You give them a t-shirt that says staff on it, right? That's not compensating because there's a good reason for them to have that t-shirt. Make a good reason to give them the ticket. Make a good reason to let them into those places where you want
Johnny,
Yes.
is there a difference in a 1099 compensation rather than a W-2 employee?
Yes, so you're asking about the difference between an independent contractor and an employee?
Well,
Or
like you mentioned
contractor
fairs,
employee?
if you have people come and do something, you give them like $50, but it's given through a 1099. They fill out a W.
So we're gonna talk about that, because
Okay.
we're,
Okay.
right now.
Okay. Well, you're welcome for this.
I'll take this one real quick.
Okay, and it might kind of be on the same lines, but as far as the giving compensation to your volunteers in the form of whether it's swag or whatnot, what about if they're volunteers that are driving to be like guides on a trip, like an event we're having, and we give them gas cards that are donated by a sponsor to help pay for that gas since they're going out and leading the trips that county employees are on? Is there, what's that?
If they're being donated from someone else,
Yes.
I would just have them get them directly from them and not have you in the food chain.
Okay.
Because as soon as you're there, now that gives the plaintiff's attorney something to say, nope, the county gave them the gas card.
Gotcha. Okay.
They compensated them, they're not a volunteer under this act. We're gonna sue them, and the county attorney's office doesn't get to cover them.
Awesome, thank you.
You mentioned some exemptions for automobiles. Is heavy equipment considered automobile?
It would be, if they're licensed, like a semi-truck, yes.
Like a
That's
Bobcat or a-
Bobcat, a grader, things like that, that's mobile equipment, that's not a vehicle under the auto, the language requiring automobile insurance. All right, so let's go back and answer Rhonda's question. So there's the volunteer, which is, they donate service without any compensation. Then we have an independent contractor, somebody who would get a 1099 because they're providing you a service for hire. The thing about that is the courts have a test to determine whether somebody truly is an independent contractor or not. And some of the main things that they look at when they determine if somebody's a independent contractor or if they're really actually your employee is, do they advertise and perform similar work to other persons? Or are you the only one that they provide that service to? Do they provide their own equipment? Or do you provide them all the equipment that they use to provide that service? Are they paid for the service? Because if you start paying them by the hour, it's another thing that the court's going to say, that's not. An independent contractor has to stand the chance to win or lose on the deal. You pay them a certain amount of money, and if the work takes more time than they originally thought, they lose money on the deal. That's an independent contractor. Somebody who's never going to lose money because they're getting paid by the hour, the court's considered an employee. Or at least not an independent contractor. And do they have control over how they perform the work? Or are you telling them exactly how to do the work? You may have plans for the building and how it will be designed for construction purposes, but you're not telling them, that independent contractor, specifically how to build a building. Or you're just giving them a scope of work to do. That's an independent contractor. And I know that over time, lots of people have learned that line, that sometimes they want to have somebody who really, they want to call them an independent contractor so that they don't have to provide them all the benefits and deal with hiring and all of that. But they're not really, because they don't, there's actually 10 things that the courts look at. I gave you the top 5 or 4 that the courts will look at that usually clearly say that person's not an independent contractor. And there's the other way around that sometimes they really should be an independent contractor the way that they're operated, but you kind of use them as an employee. And of course, volunteers, the other area that we want to pay them something, so they're volunteers, but we're gonna pay them through a 1099. Sorry, Rhonda, that doesn't help. All that is evidence.
But you want them to keep coming back, you want to take care of it.
Yes, so just, again, find a way to really verify that they are an independent contractor. Or we're gonna talk about ways to lessen your liability, to use them as a volunteer, and ways that maybe, again, they can volunteer to somebody who can pay them, who will then provide their service to you.
Got a question.
Yes.
In our oil fields out in Duchesne County, we have oil companies that provide their own graders for their roads, and they sometimes come on our infrastructure, grade our roads for their facilities. What liabilities do we hold in that case where they provide the service, don't charge for it, but they're out there working on our right of way?
So somebody's providing what could be called a service to the county, but it also is a service to themselves. That's a good question. I don't know that you didn't ask them to do it, so, and you certainly didn't authorize them, so I don't think that they would be considered a volunteer.
But we said thank you.
Yeah, right.
If you said thank you by way of payment,
But then you're okay. So again, the argument would be if that person, while they're grading your road, caused an accident, injured someone, they got injured themselves, all of those things, you treat them as a third party. I don't see how you could possibly argue that they are your volunteer because you didn't go through this process to approve them. If you did want to protect them under this, again, you could either have the individual that's driving the grader be a volunteer to the county, or you would negotiate, work with their employer and have the employer be a volunteer facilitator providing the county volunteers. So you may understand that better as when we get down the road here. Ms. Carla.
Yeah, my question is like we have election judges, we pay them to come to training, and then we pay them for election day, which makes them an employee, right? What if we pay them to train with the condition they get that payment for training only if they volunteer later? Can you do that? Is that a way to get around that? So we would pay them the full amount to train, and they are volunteering on election day.
Again, it'd be an issue that would have to be sorted out in the courts. They can't. You're not going to let them be there on election day if they didn't do the training, right? So I'm concerned that the courts would
Not a
see
loophole,
that.
right?
You're right. That loophole probably doesn't cut it. That we're going to only pay them for this because we're pretty sure they won't get hurt or hurt anybody during training. But the day of, where they could, sexually harass someone, do something like that on election day, we don't want to cover them then, so we're not paying them that day. Maybe, but Corby and our attorneys would scratch their head on that one. That would take some defending.
You have to pay someone to volunteer. You have to pay someone to provide you volunteers. And they can pay.
Well, yes, you could have an agreement with someone.
99, you did that.
Yeah, if you have someone in the community who says, we have volunteers to our organization, we know that you need some services, so our organization is going to contract with you to do some work. We're going to use volunteers to do that work, but you're going to pay us to do the work. That other organization is an independent contractor, in my mind. Just the fact that they are using volunteers, they will have to deal with their volunteers on their own. If it's a nonprofit entity, they've got some immunities. If they're not a nonprofit entity, they're open to lawsuits from those people. All right. So beat that course. Don't pay them anything. If you want to compensate them for meals and gas and things like that, just have them turn in receipts and you can reimburse them for actual expenses, no question.
How, and I shouldn't ask you how they get paid, how does the federal government get away with the multiple programs they run, like foster grandparent program, where they pay $2.70 an hour stipend and pay for lunches and do those things? The AmeriCorps program, I would manage at one time 5 AmeriCorps Vista volunteers, and they got paid a $750 a month stipend, plus certain things that they were reimbursed for expenses and things like that, but they were still considered a volunteer. And
That's just the choice of Congress, because Congress doesn't have these types of things in their laws, that volunteers to federal programs can, many of them get immunities and they can be paid. So if this is something down the road that counties really want to be able to pay something to volunteers, and actually I was working with a couple of commissioners this last session about starting that process, some minimal amount of payment to volunteers, and all it takes is a bill to be passed and the governor will sign it, and then we can start doing that. But right now we can't. I'll put you on the list for that. All right, purposes for which volunteers are employees. They are your employees if they meet that definition of volunteers for workers' compensation medical benefits only. For liability, so they get sued for anything they did while volunteering, that's your liability, that's the county. And for automobile liability. So if they get in a car accident, it's your responsibility, the same as if they're an employee. Now, I mentioned that workers' compensation is medical benefits only. If your volunteer works at the grocery store during the day and they get injured while they're volunteering on the weekend to the fair, and now they can't work for a week at the grocery store because they're injured, they don't get any lost time benefits for missing their day job under this program. They just have to use sick time at their day job. But it's still better than what any other volunteer gets, right? Other volunteers just don't get anything. John?
Just like for volunteer firefighters, my understanding.
We'll get to that. Because there's always exceptions, John. Do you not know my presentations?
You're working in there.
Always exceptions. And here they are. If the person is a volunteer safety officer, they're going to get lost time benefits as well as medical. Volunteer safety officer is someone who exercises peace officer authority, which is defined in the statute elsewhere, under the supervision of an agency, or if the agency is a fire department. The volunteer is on the rolls of the agency and not regularly employed as a firefighter by the agency. So if they're a paid volunteer, but you try and say, well, not that day, they were volunteering that day, so they're only going to get certain benefits. No. They get lost time benefits as well as a volunteer to a fire department. And their benefits, if they're a peace officer or fire, their benefits are based on the statewide average weekly wage. Not their own wage, but the statewide average weekly wage. So high wage earners in their day jobs kind of get the shaft here. Low wage earners at their day job or no day job, they get off pretty well for that. Also, volunteer search and rescue was added a couple of years ago. So if they're certified as a member of a county sheriff's search and rescue team, which comes up often, there's a lot of search and rescue teams that are not the sheriff's search and rescue team. They're a private entity, a group that has a search and rescue team that then the team volunteers to the sheriff when they want, but they're not the sheriff's volunteers. That's a sticky situation. So if that's the case in your county, we need to talk about that. and they're acting in the capacity of a member of the supervising county sheriff's team at the time that they're injured. So they're not covered all day long. They're only covered while they're doing a search and rescue mission. Then they get the benefits based on the starting wage of a deputy in your county. Okay? Whatever that is. Now, because you're going to pay them lost time benefits as well, for those of you who, the HR directors, I know what the experience mod is on your workers' compensation. When you have claims, when you have a claim and you just pay medical benefits, only a small portion of that actually goes to the experience modification factor, which is a multiplier on your workers' comp premium, that if your experience mod is 1, which is average, then you pay standard premium. If your mod is 0.8, you only pay 20%, or you get a 20% discount because you're safer than the average bear. If your mod is 1.2, you pay 20% more for every single employee in the county because your average is higher than what it should be. So regular volunteers who only get medical benefits will impact your experience mod negligibly. But you get a few of these guys that are getting the lost time benefit where 100% of the loss goes towards your experience mod. These volunteers could significantly impact what you pay for every single volunteer or every single employee in the county. So just a warning, I'm not saying don't use them because they're necessary, but just know that they can have a significant impact.
Johnny?
Yes.
Question on the firefight, volunteer firefighters. We like to use the term volunteers, but if we pay them a stipend or training costs or on-call costs, how does that affect us?
Again, if you're paying them anything, John, they're no longer a volunteer under this act.
So, technically I have 0 volunteer firefighters.
That's my position.
They work really cheap.
Yes.
So what does that do to me liability?
That means that you're responsible for them the same as any employee, and you might as well just make them a part-time seasonal employee and deal with it.
So, yeah, and I think that's kind of how we.
Melissa, do you?
So I was just gonna say, that's what the IRS says too. That volunteer firefighters are employees.
URS has given us great gratitude, but.
No, the
Yeah.
IRS.
And the URS.
Oh, okay.
Yeah, I can see where URS would have some issue with it too.
So
They want their piece.
Because like we do a stipend, $200 a month for a fire chief, which is nothing, but maybe it would be better that he gets new Oakley sunglasses for.
Again, no. That's still compensation. If it's actual protective equipment, John,
Yeah.
you're right on. Good loophole. But if it's something that they're going to use, and again, of course, now it's public equipment. If you give it to them as protective equipment, can they use it for personal use? No, not unless you've authorized it, and they use it more on the job than they do for personal use. That's a good conversation to have. That they are employees. Why are you calling them volunteers? Excuse me. Got one here.
Can the county distance themselves by having compensation go through like a multi-jurisdictional group? For instance, a task force providing compensation to volunteers?
Most task forces are interlocal agencies.
Right.
So yeah, the county can transfer the liability to the interlocal, but the interlocal then is going to have to deal with the cost of all of this. But yeah, if you're concerned, particularly law enforcement, these guys, yeah, if they're part of a task force instead, that's an interlocal agency. Now, the interlocal agency's workers' compensation mod goes up, and it doesn't impact all the counties. Doesn't impact the cost for the road department. All right. Issues with volunteer workers' comp claims. It limits liability as the workers' comp is the sole remedy against the employer, so that's a good thing. The employee cannot come back and sue, or the volunteer can't sue you in court for negligence that, you know, I got injured really, really bad and all you're paying me is workers' comp benefits? I'm suing you. They can't. They only get those benefits. Their case in court will be thrown out very quickly. So that's a good thing. One of the reasons you would want to have them be your volunteer. They can, workers' comp benefits can be misused as a way to get treatment for items that aren't covered by their medical insurance. And I hate to say it, but I have had that situation in the past where we had some volunteers that came and wanted to volunteer just so that they could start getting their back fixed, tweaked by the chiropractor workers' comp because their health insurance wouldn't pay for it anymore. Just sorry to be cynical, but it happens. So that's one of the things to consider as far as do we want to provide workers' comp benefits to volunteers. And if they're receiving lost time benefits and they don't have a job to return to, or their other job says you don't come back until you're 100%, again, they could be out a long time and really cause some havoc with your costs down the road. And that experience mod is going to jump for 3 years based on their injury. Again, the losses are counted against the experience mod and counted against all employees. So that's workers' comp. You're also liable for them for liability. Any injury to persons or damage to others' property, you're responsible for that volunteer's actions the same as if they're your employee. Civil rights violations, discrimination, harassment. So I know you're all doing lots of discrimination and sexual harassment training. I do that all the time out in the counties for your employees. How many of you provide that training to your volunteers? Why not? Can a volunteer sexually harass someone at the fair? And you are responsible for them the same as you are for an employee. State claims for injury to or damage to property are protected by the immunities and tort caps. So we will defend based on that and hopefully get the volunteer's name stricken from the lawsuit because now they're an employee. And that people can't sue individual employees of the county, they can only sue the county. So if you're named in a lawsuit, we get your name removed pretty quickly. That's what we do for the volunteer. Protection and indemnification normally afforded a paid government employee is some of the language that we saw that's in the statute. So again, because you owe them protection that you owe a paid government employee, 63G 7902 requires the agency to defend and pay all judgments against any employee, and therefore any government volunteers under this act. So as the county attorneys in the room know, the 63G requires that the county attorney prosecute and defend all claims against the county. So if that volunteer is sued for injuring somebody while they're volunteering, the county attorney by statute is required to defend them as a county employee. And so they call us, and Corby hires an attorney that specializes in the area to assist the county attorney in defending them, but it is the county's obligation to defend them. You have to. Now, if your volunteer gets in a situation where they're going to get sued in federal court because they discriminated against someone, they turned away a certain minority at the gate and wouldn't sell them a ticket, or they patted someone on the backside during the fair, that's in federal court. There are no immunities and there are no tort caps. Just recognize that. That's why I say that type of training is very important for your volunteers. Or just don't have them in a situation where they can be mentors, sort of thing. So just be aware of that. And if you have volunteers that are volunteering over state lines, Rhonda and the Arizona border, you went to the border there, if they're across the border, again, depending on the state you're in, there may not be any immunities or tort caps available in those other state courts. Auto liability, if they're driving a county car, we're going to treat them the same as an employee. So this is the same way we cover it for an employee. If the employee is driving our car, the county car, we're first and cover the claim. Because in Utah, like any other state, insurance is on the vehicle, not on the person. It's on the vehicle. And anybody that drives that vehicle with permission and steal it is covered under that policy. When the employee is driving their own car, their insurance is going to come first. So is a volunteer, because they're an employee for an automobile. Their insurance would be first. If their limits, if they only buy the minimum limits in Utah, which a lot of people still do, I don't know why you only buy minimum limits, but a lot of people do, then the county's limits would be over and above theirs, but their insurance should respond first. But we're going to work to defend that claim right from the start, because we're going to assume that it's going to blow through their limits. All right, so let's review real quick. A general volunteer gets workers' compensation medical benefits and liability, including auto liability. A volunteer safety officer gets workers' compensation medical and lost time benefits paid at the statewide weekly wage, and liability, including automobile liability. A search and rescue team member gets workers' comp medical and lost time benefits at the starting deputy wage, and they get liability, including auto liability. And then a compensatory service worker gets workers' compensation medical benefits only. You are not responsible for their liability or auto liability. And usually we don't let the guys in the orange jumpsuits just take off the vehicle. Here's the keys. We trust it. All right. Others that don't clearly fit. Student interns. Where do they fall? Are they really volunteering and providing a service to the county? Or are they meeting the obligations that they have to graduate and providing a service to the university? You're providing the university a service by letting their interns come to the county to do their internship. Is my position. But again, you need to make that call. If you regularly have student interns doing their internship at the county, talk about this and decide, do we want to have them covered under this? There's pros and cons. Do we want to have them covered as a volunteer, or do we want to make it clear with the university they are not a volunteer, they cannot provide service to us. So don't claim that they're providing a service to us. Explorer type programs. Many of your sheriffs have those types of programs. Again, if they're just learning things is one thing, but if they're providing a service to the sheriff, and the service is they're learning how to be a good cop so that they'll come and join our department later. It's a recruiting procedure. It seems to me that that's a lot of what it is. But if they're actually providing a service, and again, go through the process of the pros and cons of providing them these benefits under the Act and preventing them from being able to sue you if something happens. Ride-alongs, are they providing a service? Is the ride-along person providing a service? And I threw it in here because sometimes people say that they are volunteering. We have these volunteer ride-along people. That's a whole different area. If you do allow ride-alongs, let's talk. Jurors. No, I'm just kidding about that one. Jurors are listed as someone who is a volunteer under this Act. Jurors and potential jurors. So as soon as you bring them into the courthouse, other state volunteers, right? For most jurors, but if you have, if you're doing justice, thank you. And so they're coming into court for the county, they're your volunteers. The moment that they come in as a potential juror and they get medical benefits under workers' comp and you're liable for them.
So then we'd also have to approve them, right?
Well, that
If we
is
knew of their
not-
existence?
It says that they are a volunteer, so yes, you should authorize them to be safe, because otherwise the argument's gonna be, hey, the statute says that me as a juror, I should have got these benefits, and now there's this claim that I'm not your volunteer, what's going on here? It's your negligence for not authorizing. Again, something that may be addressed with the legislature. And school or community group volunteers. So again, the school gets a bunch of volunteers, and now they're going to come and do something supposedly for the county. Whose volunteers are they? That's something to worry about before they show up. So again, some pros and cons to consider when you're making that decision. Authorization is accepting liability, but it prohibits lawsuits by the volunteer. Pro or con. It provides immunities and limits claims against the volunteers to the tort tax. So again, that's a plus if you're trying to recruit volunteers that, hey, we're going to authorize you, and if you do something that injures somebody, you don't have to worry, we're going to defend you. And worst case scenario, the county will have to pay a judgment, and it's limited. That's a nice thing that they get as a government volunteer that they don't get anywhere else. So it may help in recruiting volunteers, but here's the other side again, as far as do we or don't we? Do you have the resources to train all those volunteers? To drug test the volunteers? Because they're your employee for liability. Do you have the resources to provide personal protective equipment to them if they should have that, based on what they're doing? Do you have the resources to supervise them while they're providing those services? And can you afford to provide all the other liability safeguards that you provide employees? And again, maybe you don't need to train them for discrimination and harassment. If they're going to volunteer, they're going to be in a room by themselves doing something with no other human contact. Okay, good, then we need that training. So again, it'll depend on what type of service they're providing. If they're out at the fairgrounds and the keys are left over the visor and they can jump in the truck and grab the keys, and then again, they should have some level of training to make sure that they understand how to operate the equipment safely and what the do's and don'ts are. So consider that. So when it comes to authorizing volunteers, I suggest you have a review and screening and acceptance process for volunteers. Many counties, and I have a couple samples back at the office, from Salt Lake and Uinta and a few others, that they actually have an application for their volunteers that you fill out, and then that goes to the HR director and the commissioners to review and determine if this is a volunteer that we want to utilize or not. Again, because they're going to be your employee, more or less, you should consider that the same as the hiring process, more or less, when it comes to discriminating against persons for volunteer services. Authorize volunteers for specific programs or duties. Because, and I recommend this, and some counties do it that way, that you don't just fill out a general volunteer and now you're a volunteer to the county. So now I can go and do whatever I want for the county and I'm covered. No, have specific volunteer programs and specific volunteers for those programs. You should even have a list of volunteer duties like you do job duties for employees. And those are their duties. This is what you do as a volunteer. Don't be doing other stuff. Make sure that all volunteers are on a roster of some sort so that you can prove that they've been authorized. And have a procedure for accepting volunteers or to review that roster and remove inactive volunteers. Because that will happen if you approve them. The statute doesn't, there's nothing in there that says that they're only a volunteer for a certain amount of time. So either when you approve them, authorize them, you are a volunteer for the 2021 fair. That's it. You're no longer a volunteer after the fair. Or you make sure that at the end of the fair, you go back and remove all the people off. Whichever way you do. But don't let them just be hanging out there as volunteers when you're not expecting them to be doing it. Have a procedure for accepting volunteers quickly when needed. The statute says that to authorize a volunteer, they must be authorized by two persons. The HR director, whoever is in that capacity for the agency, always. And the executive, which Cache County is the executive, Summit County it's the county manager, and commission counties it's the chair of the commission. Or that person's designee. So for things like search and rescue, even some fair volunteers and things, many counties, the executive will designate the sheriff or the fair director or the health department director, if they have an in-county health department, that they can designate in their name. And now that department head can get together with the HR director and authorize volunteers quickly. They don't have to wait and try and track down the chair of the commission because God only knows where they can be, right? On a Saturday afternoon when they have to get 10 more volunteers. And review duties assigned to volunteers and consider restricting volunteers from high-risk duties. That's always a good option. Consider changes to your county personnel policy. Right now, your policy doesn't speak to volunteers at all. You know, in some ways you could do that because the statute already says they're an employee, so wouldn't that mean that the personnel policy applies to them? But I would say, if you don't say employees and volunteers, or you have in your policy, your HR policy, that volunteers are considered employees, therefore all of these rules and requirements follow to all volunteers, or have a separate policy for volunteers. But somehow you need to deal with these guys in your HR policies. Consider how you're going to discipline a volunteer, right? Because an employee, we all know how we discipline an employee, but how do you discipline a volunteer? All right, you're gone. Okay. Don't ask me to come back next year. We won't. But again, look through your policies and see how you're disciplining employees and ask yourself the question, can we discipline a volunteer in this manner? Or do we need some other way to discipline? Or should this policy, this particular rule, even apply to volunteers? That's your Monday morning project, HR directors, to consider those things. And consider that before you have a big rush of volunteers. Again, provide safety training and equipment if it's appropriate, and consider whether or not you're going to need to include your volunteers in your drug testing program. Using someone else's volunteers is a good way to, if you're kind of on the fence, I don't know if we really want to authorize them or not, if you want these liabilities, because a volunteer facilitator, someone who facilitates finding volunteers for someone else, like the chamber is one that I see all the time, or a charity group in your county. They have a bunch of volunteers, and those volunteers want to provide services to the county. They have immunity under the act. The volunteer facilitator does. unless that the act is grossly negligent, not made in good faith, or with malicious intent. So again, it's that higher standard than the normal nonprofit if they're a volunteer facilitator. So if you have the chamber, they're the chamber's volunteers, and you have the agreement, like we talked about earlier, with the chamber, that the chamber's going to provide this service as part of the event, and they're going to use their volunteers to do it. They're not your volunteers. If you don't want them to be your volunteers. Again, federal volunteer programs, if they're federal volunteers, let them volunteer, but they're not your volunteers if you don't want them to be. If you want them to be, then authorize them under this act. Have an agreement with the other party that they are providing their volunteers to provide you service, not that they are identifying volunteers that will volunteer to you, unless that's what you really mean. That's an option too. If you're having trouble recruiting volunteers, they know how to recruit volunteers, and you want them to recruit volunteers for you, fine. If you're willing to accept the liability. There are some specialized volunteers in the code. Volunteer health practitioners have immunity under 5813.2 for care provided during a declared major public health emergency for actions that are not grossly negligent or intentional. So that's even another higher bar. And Jeff, we've had a lot of this lately, haven't we? A lot of volunteer health practitioners that have utilized this immunity as they provided services during COVID as a declared major public health emergency. So that's there anytime. So again, they're covered under that. There'd be no reason for you to necessarily authorize them as a volunteer because they're volunteering first to the health department. And the code just says they can volunteer. So I think that's an exception to the shall not provide service unless. Again, if that's a concern of yours, we can review that more with county attorneys. There's also volunteer health practitioners are considered employees of the state for purposes of receiving workers' compensation medical benefits for injuries, which is the volunteer's sole remedy. So it already clearly says that they're not really the volunteer under the Volunteer Government Workers Act, because all of them, if they get injured, the state pays for it. So those guys aren't going to impact your workers' comp. And 26A1 allows a local health department to establish a medical reserve corps. And medical reserve corps is volunteer health practitioners who are retired and no longer have their license. Correct me if I'm wrong here, but pretty much if they're retired, they don't have their license, they can still come back and volunteer services without having to jump through all the hoops of getting recertified and everything, and they're okay, and they're immune from lawsuit.
Although we typically want them to keep a license.
Yes, it's always best. And again, if they're volunteering during an emergency, they should qualify for immunity under 26A. There were a whole bunch of new immunities created for all kinds of people and volunteers and volunteer programs during COVID-19. The problem with new immunities is that they very likely violate the Utah Constitution under the open courts rule. And the open courts rule simply says that if someone has a right to sue someone at some point, the legislature does not have authority to take that right away. And we learned that a couple years ago when the Utah Supreme Court threw out the medical malpractice tort act. Years ago, the state legislature said doctors are getting sued too often, and it's driving up medical costs, and it's driving doctors away from practice because of the cost of medical malpractice insurance. So we're going to limit. Somebody that has a medical malpractice claim in Utah cannot sue that doctor for more than $450,000. And after years and years, somebody we said, no, you can't do that. Because my client used to be able to sue that doctor for however much their injuries were worth. And now the legislature limited it to $450,000. And the Constitution says you cannot close off the courts to someone who's had that right in the past. Now, we still have our immunities for government because until the 60s, 70s, you couldn't sue the government at all. End of story. But then the feds said, well, we're going to let you start suing the federal government for some things. And like dominoes, the states started also doing the same thing. That we have sovereign immunity. You cannot sue the county in Utah, except here's a list of things that that the counties waive their immunities for. That's why we can still have immunities, because nobody before the tort caps and the immunities, they couldn't sue at all. So we didn't take away a right like we did. But creating these new immunities, unless it's a new activity that no one has ever had a right to sue for in the past, I don't think that any of these new immunities that the legislatures gave us are going to stand up. Review, so for those attorneys in the room, review that clinical ground practice limitation case. It's very interesting. I'll be glad with that. So I'm late for lunch. This is not right. But I like that it was because there was a lot of questions, because a lot of questions mean that it is an interesting topic, and so I'm glad that we spent the time on that. Any last minute questions before we go out? If not, we're going to have lunch out again on the patio. Be sure to stop and pick up your ticket, depending on if you want salad or sandwich. Pick it up on your way out, set it in front of you on the table, and that way your server will know which way to put it. So, thank you.